was confirmed 96-3. And by the way, I voted for both Ginsburg and Breyer. Seems like a long time ago now. We spent a lot of energy in recent weeks debating this matter. I think we can all acknowledge that both sides in the Senate have sort of parallel oral histories about the last 30 or so years. Each side feels the other side struck first and struck worst, and has done more to electrify the atmosphere around here about confirmations. Now, predictably enough, I think our account is based on what actually happened, what actually occurred, factually accurate. I was there. I know what happened. I've laid it out earlier, and I'll talk about some of it again so the American people may understand how we got to where we are. It was the Senate Democrats, our colleagues over here, who amazingly enough don't seem to be on the floor at the moment, who spent the early 2000s boasting about their brand new strategy of filibustering qualified nominees from a Republican president. They were proud of it. They found a new way to halt the process, stop those crazy right-wing judges that Bush 43 was going to send up. They pioneered it because they knew what the precedent was at that point. At that point, as we discussed before, it just wasn't done. Oh, you could do it. You could, but you didn't. And the best evidence that you shouldn't do it was the Clarence Thomas nomination, confirmed 52-48. And all of us know that any one of us in this body has a lot of power to object. So if any one of the 100 senators at that time, including people who were virulently opposed to Justice Thomas, like Joe Biden and Ted Kennedy, could have made us get 60 votes and Clarence Thomas would not have been on the Supreme Court. That's how strong the tradition was until the Democratic leader led the effort in the early 2000s to establish the new standard. Well, after establishing a new standard, they got kind of weary of it, and in 2013, the so-called nuclear option was implemented because Republicans were holding President Obama's nominees to the same standard that they themselves had created. So when the shoe got on the other foot, they didn't like it too much. It was too tight. Senate Democrats, both in 1992 and 2007, helpfully volunteered how they would have dealt with a nominee like we did in 2016. The then chairman of the Judiciary Committee, Joe Biden, helpfully volunteered in 1992 when Bush 41 was running for re-election that had a vacancy occurred, they wouldn't fill it. There wasn't a vacancy, but he just helpfully volunteered how they would deal with it if they had one. If there's a vacancy, won't fill it. Well, to one-up him, Leader Harry Reid and his friend, now the Democratic leader, Chuck Schumer, said 18 months before the end of the Bush 43 period, if a vacancy on the Supreme Court occurred, they wouldn't fill it. That's a fact. What we're talking about here are the facts about how we got to where we are. I understand my Democratic friends seem to be terribly persuaded by their version of all of this. All I can tell you is I was there, I know what happened, and my version is totally accurate. The truth is, on all of this, we owe the country a broader discussion. Competing claims about Senate customs cannot fully explain where we are. Procedural finger-pointing does not explain the torrent of outrage and threats which this nomination and many previous ones have provoked from the political left. There are deeper reasons why these loud voices insist it is a national crisis. You just heard it. It's a national crisis when a Republican president makes a nominee for the Supreme Court. Catastrophe looms right around the corner. The country will be fundamentally changed forever when a Republican president makes a Supreme Court nominee. They've hauled out the very same tactics for 50 years. 50 years. Some of the opposition is more intense, but the doomsday predictions about the outcome of nominating these extremists like John Paul Stevens, David Souter, I mean, the country was hanging in the balance? Really? Well, somehow everyone knows in advance that nominations like Bork, Thomas, Alito, Gorsuch, Kavanaugh, and Barrett are certain to whip up national frenzies, while nominations like Ginsburg, Breyer, Sotomayor, and Kagan are just calm events by comparison. This glaring asymmetry predates our recent disputes. And it comes, my colleagues, from a fundamental disagreement on the role of a judge in our republic. We just have a fundamental difference of opinion. We just heard the Democratic leader name all of these things that are threatened by this nominee. Sounds very similar to the tunes we've heard before. Well, we, like many Americans, want judges to fulfill the limited role the Constitution assigns to them. Stick to text, resolve cases impartially, and leave policymaking to the people and their representatives, which is what we do here. We just spent 4 years confirming brilliant, qualified constitutionalists to the Supreme Court and lower courts who understand their roles. 53 circuit judges, over 200 judges in total, and we're about to confirm the third Supreme Court justice. What they all have in common: brilliant, smart, and know what a judge is supposed to be. But the left thinks the framers of our country got this all wrong. They botched the job. The people who wrote the Constitution didn't understand what a judge ought to be. Several Senate Democrats have reaffirmed in recent days during this discussion. They actually find it quaint or naive to think a judge would simply follow the law. Quaint or naive. Scalia used to say, if you want to make policy, why don't you run for office? That's not what we do here. Gorsuch said we don't wear red robes or blue robes, we wear black robes. What they want is activist judges. They've made it quite clear. The Democratic leader just a few minutes ago had made it quite clear. So what they're looking for here is a small panel of lawyers with elite educations to reason backward from outcomes and enlighten all the rest of us. Enlighten all the rest of us with their moral and political judgment. Whether the Constitution speaks to the issue or not. They know best what's for us. No matter what the Constitution or the law may say. And, you know, for the last several decades, in many cases, that's what they've gotten. One activist decision after another, giving the subjective preferences of one side the force of law. Across a variety of social, moral, and policy matters like a healthy society would leave to democratic debate, the personal opinion of judges have superseded the will of the people. Now, they call that a success, and they want more of it. President Obama actually was refreshingly honest about this. He said he wanted to appoint judges who had empathy. Well, think about that for a minute, colleagues. What if you're the litigant before the judge for whom the judge does not have empathy? You're in tough shape. You're in tough shape. So you give them credit for being pretty honest about this. That's what they're looking for. The smartest leftish people they can put to make all the decisions for the rest of us, rather than leaving it to the messy democratic process to sort these things out the way the framers intended. And that is why, it's clearly why we have taken on such an outsized, combative atmosphere with regard to these confirmations. That's why they've become so contentious. Because they want to control not only the legislative body, but the judicial decisions as well. Let me just say this, there's nothing innate about legal training that equips people to be moral philosophers. There's just nothing inherent in legal training that equips people to be moral philosophers. And incidentally, as I just said, that's why these confirmations have taken on such an outsized, unhealthy significance. The remarks we just heard from across the aisle show exactly why the framers wanted to stop the courts from becoming clumsy, indirect battlefields for subjective debates that belong in this chamber and over in the House and in state legislatures around the country. The left does not rage and panic at every constitutional judge because they will simply enact our party's policy preferences. Any number of recent rulings make that very clear. The problem that every judicial seat occupied by a constitutionalist is one fewer opportunity for the left to go on offense. For the left to go on offense. At the end of the day, this is a valid debate. The difference of opinion on the judicial role is something the Senate and our system are built to handle. But there's something else, colleagues, our system cannot bear. As you've heard tonight, we now have one political faction essentially claiming they now see legitimate defeat as an oxymoron. They now see legitimate defeat as an oxymoron. Our colleagues cannot point to a single Senate rule that's been broken, not one. They made one false claim about committee procedure, which the parliamentarian dismissed. The process comports entirely with the Constitution. We don't have any doubt, do we, that if the shoe was on the other foot, they'd be confirming this nominee. And have no doubt, if the shoe was on the other foot in 2016, they'd have done the same thing. Why? Because they had the elections that made those decisions possible. The reason we were able to make the decision we did in 2016 is because we'd become the majority in 2014. The reason we were able to do what we did in 2016, 2018, and 2020 is because we had the majority. No rules were broken whatsoever. So all of these outlandish claims are utterly absurd. And the louder they scream, the more inaccurate they are. You can always tell that. Just check the decibel level on the other side. The higher it goes up, the less accurate they are. Our Democratic colleagues keep repeating the word illegitimate, as if repetition would make it true. If you just say it often enough, does it make it true? I don't think so. We're a constitutional republic. Legitimacy does not flow from their feelings. You know? Legitimacy is not the result of how they feel about it. You know, you can't win them all, and elections have consequences. And what this administration and this Republican Senate has done is exercise the power that was given to us by the American people in a manner that is entirely within the rules of the Senate and the Constitution of the United States. Irony, indeed. Think about how many times our Democratic friends have said, been berating President Trump for allegedly refusing to accept legitimate outcomes he does not like. How many times have we heard that? President Trump won't accept outcomes he does not like. Well, they're flunking that very test right before our eyes. That's their problem. They don't like the outcome. Well, the reason this outcome came about is because we had a series of successful elections. One of our two major political parties increasingly claims that any political system that deals them a setback is somehow illegitimate. And this started actually long before this vacancy, as we all know. 1 year ago, Senate Democrats sent the court, directly, an amicus brief that read like a note from a gangster film. They wrote, "The Supreme Court is not well." In their amicus brief, the Supreme Court is not well. Perhaps the court can heal itself before the public demands it be restructured. In March of this year, the Democratic leader stood outside the court, went over in front of the court, and threatened multiple justices by name. Here's what he said: "You won't know what hit you if you go forward with these awful decisions. You will pay the price." That's the Democratic leader of the Senate in front of the Supreme Court, mentioning justices by name, and in effect saying, if you rule the wrong way, bad things are going to happen. For multiple years now, Democrats in this body and on the presidential campaign stump have sought to revive the discredited concept of court packing. Every high school student in America learns about Franklin Roosevelt's unprincipled assault on judicial independence. So now they're thinking about repeating it. Former Vice President Biden, who's spent decades condemning the idea here in the Senate, obediently says he'll look into it. Most importantly, the late Ruth Bader Ginsburg said last year, when asked about this, she said 9 is the right number. That's the vacancy we're filling right now. I don't think any of them have quoted her on this issue lately, have you? Ruth Bader Ginsburg said 9 is the right number. These latest threats follow decades of subtler attempts to take independent judges and essentially put them on political probation. If you don't rule the way I want, something dire might happen. How many consecutive nominees have Democrats and the media insisted would, quote, tip the balance of the court? How often do we hear that? Tip the balance of the court. Has anyone tallied up how many hard right turns the courts have supposedly taken in our lifetimes? All this ominous talk is a transparent attempt to apply improper pressure to impartial judges. Rule how we want, or we're coming after the court. Rule how we want, or we're coming after the court. Vote how we want, or we'll destroy the Senate by adding new states. These have been the Democratic demands. This is not about separation of powers. It's a hostage situation. A hostage situation. Elections come and go. Political power is never permanent, but the consequences could be cataclysmic if our colleagues across the aisle let partisan passions boil over and scorch the ground rules of our government. The framers built the Senate to be the nation's firewall. Over and over, this institution, our institution, has stood up to stop recklessness that could have damaged our country forever. So tonight, colleagues, we're called on to do that again. Tonight, we can place a woman of unparalleled ability and temperament on the Supreme Court. We can take another historic step toward a judiciary that fulfills its role with excellence, but does not grasp after power that our constitutional system intentionally assigns somewhere else. And we can stand loud and clear that the United States Senate does not bow to intemperate threats. Voting to confirm this nominee should make every single senator proud. So I urge my colleagues to do just that.
Clerk will call the roll.
Mr. Alexander. Present. Ms. Baldwin. Mr. Barrasso. Present.
A quorum is present. Can I read? All post-cloture time has expired. The question occurs on the nomination of Amy Coney Barrett of Indiana to be Associate Justice of the Supreme Court of the United States. A senator. Is there a sufficient second? There is a sufficient second. The clerk will call the roll.
Mr. Alexander. Aye. Ms. Baldwin. No. Mr. Barrasso. Aye. Mr. Bennett. Mrs. Blackburn. Aye. Mr. Blumenthal. No. Mr. Blunt. Aye. Mr. Booker. No. Mr. Bozeman. Aye. Mr. Braun. Aye. Mr. Brown. No. Mr. Burr. Ms. Cantwell. No. Mrs. Capito. Mr. Cardin. No. Mr. Carper. No. Mr. Casey. No. Mr. Cassidy. No. Ms. Collins. Mr. Coons. Mr. Cornyn. No. Ms. Cortez Masto. Mr. Cotton. Aye. Mr. Kramer. Aye. Mr. Crapo. Aye. Mr. Cruz. Aye. Mr. Daines. Aye. Ms. Duckworth. Mr. Durbin. Mr. Enzi. Aye. Ms. Ernst. Aye. Mrs. Feinstein. Mrs. Fisher. Aye. Mr. Gardner. Aye. Mrs. Gillibrand. Mr. Graham. Mr. Grassley. Ms. Harris. Ms. Hassan. Mr. Hawley. Mr. Heinrich. Ms. Hirono. Mr. Hoven. Mrs. Hyde-Smith. Mr. Inhofe. Mr. Johnson. Mr. Jones. Mr. Kane. Mr. Kennedy. Mr. King. Ms. Klobuchar. Mr. Langford. Mr. Leahy. Mr. Lee. Mrs. Leffler. Mr. Manchin. Mr. Markey. Mr. McConnell. Ms. McSally. Mr. Menendez. Mr. Merkley. Mr. Moran. Ms. Markowski. Mr. Murphy. Mrs. Murray. Mr. Paul. Mr. Perdue. Mr. Peters. Mr. Portman. Mr. Reed. Mr. Risch. Mr. Roberts. Mr. Romney. Ms. Rosen. Mr. Rounds. Mr. Rubio. Mr. Sanders. Mr. Sass. Mr. Schatz. Mr. Schumer. Mr. Scott of Florida. Mr. Scott of South Carolina. Mrs. Shaheen. Mr. Shelby. Ms. Sinema. Ms. Smith. Ms. Stabenow. Mr. Sullivan. Mr. Tester. Mr. Thune. Mr. Tillis. Mr. Toomey. Mr. Udall. Mr. Van Hollen. Mr. Warner. Ms. Warren. Mr. Whitehouse. Mr. Wicker. Mr. Wyden. Mr. Young. Senators voting in the affirmative: Alexander, Barrasso, Blackburn, Blunt, Bozeman, Braun, Burr, Capito, Cassidy, Cornyn, Cotton, Kramer, Crapo, Cruz, Daines, Enzi, Ernst, Fisher, Gardner, Graham, Grassley, Hawley, Hoven, Hyde-Smith, Inhofe, Johnson, Kennedy, Langford, Lee, Leffler, McConnell, McSally, Moran, Murkowski, Paul, Perdue, Portman, Risch, Roberts, Romney, Rounds, Rubio, Sass, Scott of Florida, Scott of South Carolina, Shelby, Sullivan, Thune, Tillis, Toomey, Wicker, Young. Senators voting in the negative: Baldwin, Blumenthal, Booker, Brown, Cantwell, Cardin, Carper, Casey, Collins, Coons, Cortez Masto, Duckworth, Durbin, Feinstein, Gillibrand, Harris, Hassan, Heinrich, Hirono, Kane, King, Klobuchar, Leahy, Manchin, Markey, Merkley, Murphy, Murray, Peters, Rosen, Sanders, Schumer, Shaheen, Sinema, Smith, Van Hollen, Warner, Warren, Whitehouse, Wyden. Mr. Menendez, no. Mr. Schatz, no. Mr. Reed, no. Ms. Stabenow, no. Mr. Bennett, no. Mr. Jones, no. Mr. Udall. Mr. Udall, no.
Senate will come to order. Are there any senators in the chamber who wish to vote or change their vote? If not, on this vote, the yeas are 52, the nays are 48. The nomination of Amy Coney Barrett of Indiana to be an Associate Justice of the Supreme Court of the United States is confirmed.